Hello, everybody, and I am glad to welcome everybody at the panel organized by International Fiscal Association at the Eurasian conference. This year we are online because of the pandemic. However, I welcome everybody and would be happy to meet you in Moscow when the situation will allow us to contact physically. Today the concept of this panel is to share the experience of the very distinguished speakers, mostly practitioners in international taxation on different actual areas. We will discuss several rather different recent development in international taxation from the different jurisdictions. And I would like to first to introduce the panels. We have today Frigo Krijveld from Netherlands law firm, and Frigo will share with us several developments related to anti-avoidance by the Dutch tax authorities and the prospects of Russia-Netherlands tax treaty. We also have Elena Ryabova from Moscow, and Elena will share with us developments in Estonian jurisdictions related to electronic tax residence, and also share some implications for Russians of these novel legislative developments. Also, we have Mikhail Volkov from Russian tax authorities, who is not only practitioner but also is involved in his personal academic research projects, and he will discuss different concepts related to the principles of application of tax treaties, including the principle of good faith and the principle purpose test in tax treaty law. We also have Ekaterina Kudryashova, who will share with us some thoughts and reflections about digital economy. And we have Martin Busenhardt from Switzerland, who will discuss problems of application of arm's length principle in the practical and conceptual contexts. And finally, we have Valeria Zamulko, who is a practitioner currently working in US industry, in my multinational, and she will share with us recent transfer pricing developments in United States, focusing on Coca-Cola case and its implications for transfer pricing in United States. So I suggest we have a lot to share and discuss today, and I would like to propose to present speaker by speaker his case, and I strongly encourage all the panel members to comment and to pose questions to the speaker if there are any after each speaker. So I think we will start with Mikhail Volkov from Russian tax authorities. Mikhail, the floor is yours.
Okay. Hello, everyone. Thank you ever so much for the opportunity to speak. I'm honored to address my topic about the principle of good faith and the principle of purpose test in the tax treaty law. But I will be brief in explaining my some reflections. I would like to comment on connections between principle of good faith and the principle of purpose test, with a stress on the issue of a tax treaty abuse from the point of international law. And firstly, I would like to define such a complex and abstract concept as a good faith. I think no one will argue that this concept may be presented in the different ways. Firstly, it's good faith in a subjective sense. Good faith very often is thought to be nothing more than a psychological concept, making reference to some sort of inner knowledge. And it seems to be a properly moral concept, searching to introduce into the law a measure of honest belief. Thus, the good faith is not a rule in the legal sense of the word, and it has no normativity. It therefore is not a source of law at all, but just a factual element of a norm, to the existence of which this norm leads to certain specified consequences. Also, we can speak about good faith in the sense of an open-ended legal standard, as the law cannot operate only with specific concepts, but rather needs some general terms in order to keep the flexibility, enabling it to apply to the myriads of cases. And it has to insert in its norms some vague notions which are called legal standards. And finally, good faith has an objective sense. In this context, it's a general norm, a general principle of law. This is by far the most important form in which good faith appears in international law. And I think that it's hard to find something more fundamental to the international law, and particularly law of treaties, than the requirement of following treaty rules in good faith. Of course, tax treaties are just a treaty, and they subject to the requirement of being followed in good faith. And this way, good faith has traditionally been associated with the observance of conventional agreements or pacta sunt servanda principle. However, it's fair to say that the actual implications of the principle of good faith haven't received that much particular notice in the field of international taxation, although it has been called upon to examine the issue of taxpayers' abuse and tax avoidance in matters of double tax treaties. And traditionally, tax scholars have mainly referred to the notion of good faith in the context of tax treaty override, but that says little on the difference between observing a tax treaties and complying it in good faith. Can, in the case of double tax treaties, the principle of good faith be the source of actual legal obligations or rights beyond the text of the treaty itself? In other words, does good faith really mean something for tax treaties? And if so, can it affect the position of the taxpayer, or is good faith only legally relevant to the contract extents themselves? As far as obviously the states are the parties of the double tax treaties, not the taxpayers. And is it possible to interpret the good faith as an inherent anti-abuse rule in tax relation? The answer on the question should be no, I think, because it's impossible, at least from the point of international public law. Other close situation to the question is an application of a domestic anti-avoidance rule to override a treaty provision. Such manner would imply a breach of international law by one of the contracting states. And it wasn't until 2003 that OECD commentaries stipulated the compatibility between domestic anti-abuse measures and treaty provisions. Anti-avoidance rules are part of the basic domestic rules determining which facts gives rise to tax liability, and they are not addressed in tax treaties, and generally there will be no conflict between such rules and the provisions of tax conventions. And if I'm not mistaken, that position was adopted by most of the OECD members, except for some states as Luxembourg, Netherlands, which observed the previous interpretation. And before the 2003 position, the OECD has the view that domestic anti-avoidance rules should be included or confirmed by treaty provisions. Particularly in regard of general anti-avoidance rules, such authors as De Brue or Lutz point out that the OECD has admitted that in treaty shopping strategies, the abused rules are related to tax treaties, and therefore it's unlikely that those situations could be addressed only by domestic anti-avoidance rules. Consequently, these are reasons why it has been determined by the OECD that there is a necessity of a coordinated process of amendment of the worldwide treaty network. And it's important to note that the principal purpose test rule is presented as one of the central commitments of the multilateral convention. And it's indicated as one of the standards of the agreement is that the signatory states were not allowed to make reservations on it, unless that minimum standard was already achieved. But from the point of view of some scholars, such as Ulf Lindeforg, there can be one more question which can be formulated as what can be achieved by MLI PPT rule that cannot be achieved by public international law through its own measures, such as a good faith. And the doctrine of abuse of rights applies equally to all international rights, whether they originate in customary international law or international agreements. And this observation prompts the conclusion that in one sense, treaty abuse is a special case of abuse rights. And if sometimes the exercise of a discretionary power conferred under a treaty is abusive, then this is because it renders the object and purpose of the treaty ineffective. This is the first element. There is also a second element. As I will suggest, the exercise of a treaty-based discretionary power is abusive when it presupposes as an understanding that is contrary to the requirement that treaties be interpreted in good faith. And this interpretation must be based on the rules of interpretation under Vienna Convention. Treaty interpretation and treaty abuse are simply two sides of the same coin. They're both instruments aimed at establishing in good faith the intention of treaty parties. This brings me back to the question that I asked earlier, what can be achieved by applying the multilateral conventions that cannot already be achieved by applying general international law? Nonetheless, I'll try to answer on these questions. Principle of purpose test is more specific rule than the general principle because it presupposes specific algorithm under which you can deny a benefit. But of course, it has some inherent problems, such as a lack of uniform understanding of its individual terms. For example, indirect benefit. But I don't think that it's a major problem because in relation to this principle, a common understanding of the terms can develop faster, taking into account the unity of the terminology used. Also, with establishing such rule in the treaty is the issue when there is no possibility to reform domestic rule or general anti-abuse principle is vanished. In conclusion, I would like to mention that in Russia, all above mentioned problems are more theoretical than practical. As far as I know, in the absolute majority of cases, tax authority based its position on domestic general anti-avoidance rule or domestic anti-avoidance rule judicial doctrine before 2017. That is all my short speech, and thank you much for the listening.
Thank you, Mikhail, for sharing your, I think, very academic kind of research with us. Dear panelists, do you have any questions or comments related to Mikhail's presentation?
Yeah, maybe from a Dutch side, but we'll touch on that later. Part of my presentation is about the renegotiation of the tax treaty between the Netherlands and Russia. I understand that Russia would like to levy, would like to have the opportunity to levy an additional withholding tax of 15%, like agreed in the treaties with Malta, Luxembourg, and Cyprus. But I thought, since we're negotiating the treaty, and if I see in practice how Russia interprets the beneficial ownership test and the PPT, wouldn't that not be part of these negotiations? They say, yeah, listen, if we have a Dutch holding company and there's effectively a Russian on top of it, even if you have 15 people, it's not. This is specifically a situation that we want to tackle in a under the principal purpose test, and we agree on these kind of situations in a memorandum of understanding, which would then form part of your, I think it's the context, the article we found in Article 31 of the Vienna Convention. It was okay. We are renegotiating it, and if we feel as a Russian authority that we're losing too much tax ground, because we have a few of these larger Russian companies that are held by Dutch entities, but the fact that there's a Russian behind it, even if you have substance, these are specifically the situations that we want to target. And if there's a Dutch, what is the flour seller? Yeah, we don't want to levy 15% on that one. How is there? I don't know, Michael, if you cannot say anything about it, I understand, but what is the Russian approach in treaty renegotiations and say building in flexibility in PPT, taking into account the limitations of Article 31 of the Vienna Convention?
Mikhail, yeah, thank you, Frigga. Mikhail, could you comment?
Yeah, thank you. I think that there should be many different rules, such as the limitation of benefits, so-called maybe something close to simplified limitation of benefits rules, and the principal purpose test, and beneficial owner test. And I think that all these rules must be used in the uniform form and maybe jointly. So we have.
Cannot hear you.
And I think on the stage of negotiation, there could be a different approach. Also, I think we can see in time maybe how principal purpose test will affect in future in Russia, because for now there is no any judicial cases which is based on implying limitation of benefits in previous form. So all cases which I know are based on general anti-avoidance doctrine or beneficial ownership test. This situation for nowadays.
Maybe one more question. Michael, can you say something about Russia's position towards a obligatory or a mandatory dispute resolution in case of tax treaty disputes? Is Russia willing to agree on a mandatory dispute resolution, or is it more an optional form?
I understood. Firstly, it should be position of the Ministry of Finance, not position of Federal Tax Authority. We have different bodies, and negotiation is firstly for negotiation responsible is the Ministry of Finance, and it will be the position and decision of Ministry of Finance.
Okay, thanks.
I could probably comment the Frigo's question, as I'm not working in the Ministry of Finance, but I'm working in the institute under the Ministry of Finance, and we are trying to be tuned in with our key stakeholder. And so, as we discussed in the other session of this conference, where the representative of Russian Ministry of Finance presented their thoughts on international tax issues, they explicitly mentioned that Russia is strongly against the mandatory and binding arbitration, and this is actually one of the key obstacle towards harmonizing the position related to Pillar 1 issue, where mandatory binding arbitration actually is part of the package related to tax certainty, early tax certainty. However, also I would like to ask also one more question to Mikhail from my side. Mikhail, so what do you think? Do we need some kind of uniform guidance, maybe from the OECD under the umbrella of BEPS project, relating to more detailed understanding and application of principal purpose test? Or do you consider that the different approaches in different jurisdictions toward interpretation and application of this principal purpose test is okay, and the already existing guidance, which include mostly rather obvious tax abuse issues, are enough? So what is your thinking about this?
Yeah, thank you, Nikolai. I think that it should be many different measures which are against treaty abuse and tax treaty abuse. I think that the principal purpose test as a general anti-avoidance rules should be abstract, because yes, and other measures, for example, simplified limitation of benefits, they can be more detailed, and it's not a problem. But if we will get very simple and very detailed anti-avoidance measure, general anti-avoidance measure, it cannot affect effectively on abuse. That is all.
I see. So your position is that it shall be brought in order to catch all the possible possibilities, yes, of anti-avoidance of avoidance schemes, and we cannot predict all the creativity of the taxpayer.
Of course, I think that it can be some sort of the algorithm and establishing the burden of proof. Some in the movie. By the way, I think yes, broad general anti-avoidance rules is much better than detailed. I think it's not creative position of mine, but I think such general anti-avoidance rule should be work. Yes.
All right. Thank you for this. Thank you for your presentation. And I think now we are moving on, and I suggest to for Frigo from the Netherlands to share his thoughts and reflections relating to Russia Netherlands tax treaty and application of anti-avoidance rules by the Dutch jurisdictions in more detail with us. Frigo, you're welcome.
I will join, and I try to. Did I share my screen now? Is that visible?
Yes, we see you.
Okay.
You are for full screen presentation. Everything is fine.
Nice, nice. Okay, good. Yeah, what I did, I made a short presentation here. Let me see, where I divided it into two parts. I will go through it quite fast. Part one is about the BEPS related developments. Here, this is an overview. I think I shared it last year as well. It also always helps me to divide all the BEPS projects into the three pillars: coherence, substance, and information transparency, and how these are implemented at the red lines into 8.1. So interest deduction, it's 8.1, CFC 8.1, hybrid mismatches 8.2. So that gives a sort of an overview where we are and how these are implemented into European rules. Then I will go here. What the Netherlands has done. So, okay, we know that the Netherlands has been criticized a lot over the past years as being a tax haven, and it was due to the to the favorable tax treaties we had in combination with the participation exemption and the fact that dividend that interest payments and royalty payments by a Dutch entity were not subject to withholding tax. So, and also because maybe the entrepreneurial side of a history of the Netherlands, that that the tax lawyers had sold, say, the tax system internationally to attract business, which was also encouraged by the Ministry of Finance and the Ministry of Economic Affairs in the Netherlands until that backfired in the discussions in Europe. Because the European Commission, especially after the financial crisis 2008 and in the past years, Southern European countries said, yeah, listen, the fact that we have budgetary deficits is not because our economy is not competitive. No, it's because of the Netherlands, because you're a tax black hole. So the Netherlands had to do something. Otherwise, if the Netherlands wouldn't have done sufficiently in Europe, we would not have any position at the negotiation table. So the Netherlands have, this is a nice overview. It shows what the Netherlands has done. So the BEPS 1 implementation to make the Netherlands less attractive. It's in a sense to ensure that all these holding and structure, the non-substantial or the structures with no substance in the Netherlands are not structured through the Netherlands anymore. These can still be structured through maybe through Cyprus or Luxembourg, whatever, but not through the Netherlands anymore. And the Netherlands doesn't want to have any situation anymore which they have to explain or that could create a scandal. Now, doesn't always work, but and here it shows that from 2019 the earnings strippings rules have been introduced. 2020 the hybrid mismatches. And remember that with every introduction, the Netherlands went further than other European jurisdictions, just to show how good we are, just to show that we go further than any other country. It's more a European negotiation thing, and also something that the Netherlands will use in the in negotiation of other treaties. Very important this year to really limit the use of interest and royalty flow through entities. The Netherlands introduced per this year a conditional withholding tax. It's conditional because the withholding tax on interest and royalties up to 25% will be levied if there's a interest or royalty payment to a related entity in a low tax jurisdiction. So that's really stopped all the interest flow throughs, intercompany flow throughs. Also, we limited and this is really harming our own economy, the limitation of liquidation loss schemes, which was used by Shell, Royal Dutch Shell and Unilever. Now, Unilever chose to move to another country, to the UK. and it reduces the possibility to take a loss for all the oil exploration in foreign jurisdictions, because there was a big upheaval in the Netherlands about the fact that Shell, although headquartered in the Netherlands, didn't pay any tax in the Netherlands, and this should limit that situation. But it's harming our own economy. But we had to do something. And furthermore, for 2022, the Netherlands now limits further loss carry forwards, and I think that's in line with the German the German system, where only up to 50% of your profits can be set off against your loss carry forward. So that means, let's say that you have a profit of 100 and you have loss carry forwards of 100, you can only use 50 of those loss carry forwards. So you end up paying on the 50, 25%, or 12.5%. You end up paying taxes, whereas on a consolidated basis, on a total profit view, there's no profit. But still, the politicians want to see taxation. They just want to have tax. Even they say on a consolidated basis, there's no taxation. So this is another measure to something for the public to show that the Netherlands is doing everything to extract or to levy taxes from for the multinationals, because we have a minimum of 1 million. Say that this rule only applies from 1 million. So the middle and small companies in the Netherlands are not targeted. It's for the multinational entities. There's something new that which is, maybe you've heard of that, the informal capital contribution rulings, where IP was contributed to the Netherlands, and then at arm's length value, and you would write off on that IP. The Netherlands is not accepting that anymore if the IP is assigned to the Netherlands or contributed to the Netherlands from a low tax jurisdiction. Again, we don't want to have these structures. We don't want to be I don't mind it much, but the Netherlands doesn't want to be associated with these type of structures anymore. And there will be an additional conditional withholding tax on dividends. Now, what the Netherlands says, okay, we implement all these rules, and coming back to the discussion we just had, what the Netherlands wants to include in the tax treaties is a binding dispute resolution in the treaties. So, okay, we include everything, and we include the PPT, and we signed up for all MLI, more or less all MLI articles except the commission agent. But in exchange, we want binding arbitration. That's not accepted by all jurisdictions. I'm gonna not. It's more for the. I will distribute that later. Do that later. But this is interesting. Tax treaty developments. This was the big news of this year. The fact that, okay, we saw that Russia wanted to renegotiate the tax treaty. Maybe the Russian speakers can speak about it a bit more later. So I don't know really what the background is, but what we saw is that Russia started renegotiating tax treaties with the primary, how I see the primary investment hubs like Malta, Cyprus, Luxembourg. I guess that Russia will also approach other jurisdictions, say the secondary part, but Russia also approached the Netherlands and say that I call them here the new Russian treaty principles. But these new, what I understand is that the new Russian treaty principles require that Russia will levy a 15% withholding tax on interest, royalties, and dividends to non-listed recipient companies. That principle is already in these tax treaties with Cyprus, Malta, and Luxembourg. And the aim of Russia was to renegotiate that as well. Now, I can understand that if you look at these, what you call the U-turn structures, where you have a Russian individual and then something in the Netherlands, and then Russia again. This, why is that entity there? We want to tax it as if it's a pure Dutch entity. But from the Dutch economy perspective, if you look at the larger family-owned companies that are in building greenhouses or are the engineering companies, the non-listed entities that are active in Russia, and Russia is one of the largest markets for the Dutch, the construction. We call it the maak-industry. It's the building industry, like engineering companies, agricultural companies. Having this 15% withholding tax on interest and royalties that would really harm the Dutch budget, and on dividends that would really harm the companies, the family companies. So this was not accepted by the Netherlands. What the Netherlands said is that they proposed some what they call themselves constructive counter proposals, and on 22nd of January, the questions in Parliament were answered about the status of the tax treaty. And interesting is that in the newspapers it was announced that Russia, I think it was by the Duma, I'm not exactly, don't know how that works in Russia, but it was proposed in the media to cancel the treaty with the Netherlands. But the Dutch Ministry of Finance responded that there was no formal cancellation received yet by Russia. Now, if a formal cancellation will be received, now what would that mean? It means that of course, a tax treaty can be unilaterally terminated, and then at least 6 months before the end of that calendar year, if it's cancelled in a year, then the cancellation will work from the 1st of January next year. So that would mean that for 1 January 2022, the treaty would be cancelled. That's big news, also because Russia is a big market for the genuine Dutch businesses, and I think vice versa that applies. So the Dutch Ministry of Finance, they really want to resolve it. Russia is a too important trading partner, and we'll see. But it's the intention of the Netherlands to find a solution. But this is all I know about the situation and the information I could share. Other interesting tax treaty developments is that the Netherlands finally, that was the only jurisdiction in Europe with which the Netherlands did not have a tax treaty, is Cyprus. Apparently, so it was now announced a few weeks ago that we have negotiated a tax treaty with Cyprus, not in force yet, and with Liechtenstein as well. Sometimes you see that for high net worth individual Russians that have some family foundation in Liechtenstein. So that's why I mentioned it. And we have continued discussion with other parties, where please note that with all these, say, African companies where there's quite some extractive industries, that the Netherlands applies more the UN model that provides more levy power to the source jurisdiction, also the management permit establishment, compared to the OECD model. So for developing countries, the principle is that in any case, the principle is always to include the PPT, but also to provide more levy rights to these source jurisdictions in third developing countries. So that is it, and I'm gonna stop sharing. Here I am. Yep. If someone has any questions.
Thank you, Frigo. Are there any questions from the panel? So I think if there are no other volunteers, I will jump in, and I would like actually to a little bit comment on Russia-Netherlands tax treaty, and on this policy shift by Russian tax authorities. From one side, actually, this policy can be seen as rather counterintuitive, yes, and very radical. Actually, taking into account that Russia is one of the members and one of the initiators, actually, as G20 country of the BEPS project, and Russia joined the MLI, Netherlands also joined the MLI, and actually, if we read all these reports supporting the BEPS project, the very goal of the BEPS project was to restore the confidence of the countries in tax treaty network by ensuring that appropriate anti-avoidance provisions are included in tax treaties. The transfer pricing methodology is now applying properly, and so if we consider that BEPS is a success, it is rather counterintuitive to renegotiate the tax treaty the next day after we agreed on all this. However, if you look more deeply from the Russian perspective, you can see that BEPS is not the only discussion in Russia. Actually, Russia has its own discussion, and you mentioned, I think, the essence of it, which is, we call it like round-tripping structures. Yes, when in fact actual beneficiaries of these structures are usually either Russian tax residents, or it can be the, I mean, natural persons, or it can be also the tax residents of other countries, for example, UK or some other jurisdictions, but with strong actually economic ties with Russia. And the essence of these structures was not in line with the view of tax authorities, and with the view of Minister of Finance, and with the view of the president and of the government of Russia. And that is why we had this de-offshorization, we call it, policy. And this de-offshorization policy was implemented with several amendments starting from 2014. We introduced CFC, we introduced definition of beneficial owner concept. We also introduced special rules for taxing capital gains from alienation of immovable property companies at source. However, after several years of living with these rules, I suggest that this experience showed that actually national account statistic, it did not change. We still have Cyprus as key investor in Russia, having 35% or something like this of all the FDI into Russia. And we still have Netherlands at the second place with 15 or something like this %, and Luxembourg at the third place. And this is the same both for inward and for outward structures, actually. And in the outward structures, actually the share of these hubs even higher. So at the macro level, and if we compare these all also with statistics at the level of Netherlands, Cyprus, and Luxembourg, we also see these huge figures when FDI account for 300% of GDP, 500%, and something like this. In Netherlands, I don't remember exactly, but it's something like 200% of GDP. So we see that all this financial flow, they're much more than the actual size of the economy. And Russia actually has its term in these tax policy proposals. Our president and our prime minister called these transit jurisdictions. Transit because it's like all these passing through structures, passing through income. And so Russia actually thought, why shall we fight with this case by case, on a case by case basis? Maybe it is much more easier to tax everything at source, and that is it. And if it is, if there is any problem, for example, for Russian companies expanding abroad, which are also using this jurisdiction, for example, to get access to Europe's financial market by, for example, issuing bonds through SPV in Netherlands or in Luxembourg, we can exempt it at our country, and there will be actually no problem even without treaty. And actually Russia have effectively done this in relation to Euro bonds a long time ago. And so it was a decision, and actually, of course, it could be questionable about Netherlands, because Netherlands have both its own economy and these financial structures, and done a lot to improve its image. However, it is a decision. I don't know how exactly criteria of the jurisdictions was analyzed, but the decision was made, and I suggest from what I know that Russia will keep to its position. Even with the Netherlands, and if the Netherlands will not accept Russian proposal, the treaty will likely be terminated, maybe at more, maybe not today, but maybe as you mentioned, from 2022. So this is my comment from Russian side as I see it.
Many thanks. Is it?
Just a small comment, maybe it will be interesting for you. Well, I suppose it's not a coincidence that all these changes and renegotiations started this year, 2020. Because first of all, we had the changes in the constitution, and it's there is a slight change of treatment of international case law, particularly, but I suppose it affects mostly the international law and its interaction with the internal law. And second contextual factor is the change of practice in corporate law, because in Russia by this time piled up the cases, then the owners of Cyprus companies, or well, I'm not sure if there was a Dutch company, but I'm sure that there are some Cyprus companies. So the owner comes up in a process, in a case, in a corporate argument, saying that I am the owner. I am the real owner of this company, and I would like to claim my rights as the owner, as the shareholder of this company. So basically, if these treaties are not renegotiated, there is a legal basis to, well, I would not say ignore, but still apply it in an internal way, like just based on these two trends. So that's the comment. I suppose it's the renegotiation is a consequence in a general trend of changes in Russian practice in corporate law and the constitutional practice.
Thank you for the explanation.
So I think we move on, and I would like to ask Elena Ryabova to share her case, which is about the developments in very geographically close to jurisdiction to Russia, Estonia, and how it impacts Russian tax residents also.
Yes,
Elena,
thank you.
Welcome.
Yes, thank you. And I want to talk about to talk about natural persons and about e-residence approach in Russia, because recently in media environment we can see some messages concerning e-residence introduction in Russia for IT foreign companies, for natural persons as bloggers, Instagram travelers, and so on. So I decided to think about e-residence approach that was that has been already introduced in Estonia. And so first of all, I want to explain this this program. So it is somewhat not about tax residence, and it is very important because it is it is program that is based on migration law, not on tax law. But recently, Ukraine has announced that there will be introduced this program e-residence for natural persons. But furthermore, I will return to this moment again. So e-residence approach in Estonia means that it is digital ID for a person, for a natural person. Digital ID, it is a digital identical card for a natural person that can be issued outside Estonia for foreigners. So it is a program. It is Estonian government's program for foreigners. And foreigners as natural persons should establish an Estonian company to carry out their business. So it is some digital company, electronic company, and this company will be established in the European Union. So the goal of e-residents to establish such companies is to entry to the EU market. Thirdly, a location-dependent business online, and maybe it is very convenient for natural persons from IT sphere, from blogger sphere, Instagram, for example, sphere, and so on. Estonia suggests a digital environment, very sufficient, very development digital environment, e-government, e-taxing, e-documentation, smart contracts, blockchain, and so on for e-residents. But this digital ID card for e-residents does not create any rights to entry, to a visa, to residence permit, and so on. So it is only digital digital company, digital residence, and digital environment for foreigners. Estonia has announced that the aim of e-residence it is not a taxes collection, of course, but maybe it is a real goal. But it is somewhat about collaboration in cultural, social sphere, economic sphere, and Estonia wants to facilitate its economic activities within this country because of the decreasing of population. Maybe it is the real cause of e-resident program is not merely collection of taxes, but maybe it is the solving a problem with of demographic problem. What about legal framework? So it is Migration Law, Identical Documents Act with a new chapter. And about tax law, it is no any changes, no any amendments to current tax law. Because irresidence or irresidence is not a tax resident. So irresident is not a tax resident in Estonia. Only digital company is deemed as tax resident in Estonia. And so to introduce this program, Estonia didn't face with the problem of changing current tax legislation. About motivation for Russians. So the most important goal is to entry to the EU market. Because it is an internal market, so it is easier to connect with different EU companies. Concerning taxing natural persons in Russia, so they may, of course, receive dividends from this company, e-company, and these dividends will be taxed in Russia. And Estonian company, of course, it is corporate income tax, but corporate income tax of 20% must be paid only if dividends is distributed. Concerning tax status of this person, it is very important and very attractive moment that such persons may not be deemed as CEO of this company or some other employee of this company. So this natural person may remain to be a shareholder. And if this person will be considered as employee, they will be taxed from salary, and social taxes will be paid as well. Benefits. So what about benefits for in the taxing sphere? Concerning national law, it is advantages, some tax advantages that corporate tax is not paid until the distribution of dividends. And concerning personal income tax and social taxes, all these taxes may not be paid if a resident remains to be a shareholder. And we don't. It's a very important moment that between Russia and Estonia, we don't have a double tax treaty, and it is very and it is not convenient for Russians who wants to entry to EU market through this program. Because according to double tax treaties, dividends distributed in Estonia can be excluded from tax base of corporate income tax. But for Russia, we don't have such an opportunity. Drawbacks of current taxation. It is very risk. It is many risk. There is many risk of dual tax residence, and of the recognition of permanent establishment in the residence country. Um, Concerning dual tax residence, say, a residence country recognizes may recognize this company as a tax residence of this country because of the effective management test, because the shareholder as natural person is a tax resident of this country. Concerning PE, it is another perspective of tax spillover, negative spillover, because this natural person might be deemed as permanent establishment of the Estonian company in the residence country. And the risk of controlled foreign companies rules exists as well. Concerning Russia, as I have mentioned already, we don't have double tax treaty with Estonia. So Estonian company must pay full corporate tax, including dividends. Russian tax residents must pay tax on dividends, of course, personal income tax. The risk of controlled foreign companies is very high in Russia because if dividends are not distributed, the effective rate will be 0, and so these rules should be triggered by Russian tax authorities. The risk of permanent establishment recognition is minimal because as our case law has shown, there is no perspective for peer recognition, but such a risk exists. And so the main goal, so we don't have obvious tax positive spillovers, so some tax benefits for our Russian residents. To enter to this program is only to entry to the EU market, maybe, as I suppose, and to obtain some a very convenient electronic environment. Concerning our current taxing remote workers in Russia, it is some problem in our theory and our tax practice because we don't know how to tax exactly, effectively bloggers, Instagram travelers, and so on. In 2018, we have introduced personal income tax for the self-employed because the self-employed is somewhat hidden sphere of taxpayers for tax authorities. But for bloggers and other remote workers, we have, of course, common regime with withholding tax 13%. But it is this regime is not sufficient for such workers. Secondly, a special simplified regime. It is a special regime that substitutes several ordinary taxes concerning personal or corporate income tax, VAT, and property taxes on individuals and on corporations. And thirdly, special tax regime as well. It is a regime for professional income tax for the self-employed. the benefits of their last regime, it is a very low rate, 4.06%, and no social taxes. It is very convenient for such remote workers. But nowadays, most bloggers and Instagram travelers and so on are individual entrepreneurs because in this situation, they can be deemed as VAT payers, and for economic activities, it is important moment. And this category of taxpayer, individual entrepreneur, it is a registered status of natural persons, may choose between two special regimes, special simplified regime, or professional income tax. And in this situation, we have some problem with in the sphere of international taxation, because our double tax treaties don't cover this tax treatment. So there is no sense to pay 4 or 6% if this person is not tax resident of Russia. Remote workers, it is some specific category of taxpayers that can move across the world, and they easily can breach our thumb test, our mechanical test, and laws, and they can easily lose the status of tax residents. And so in this situation, we don't have any tax regime for such workers. And nowadays, it is some challenge for, I think, for as for domestic tax law and for international law. And concerning a residence approach of Russia, I think about the main goals to introduce some approach, because in media sphere, in media, we can face with these messages and take it into account the announcement of the Ukraine to introduce this approach, but Ukraine wants to introduce tax residence and to change tax legislation. And Estonian experience is experience not about taxes. It's about economic activities, and Ukraine wants to introduce tax electronic residence for self-employed. It is something new, tax, digital tax residence for natural persons. And I think, could we create a tax residence for natural persons? Could we Russians create such regimes, such a regime for our remote workers? Because we have only one tax resident test, only mechanical, all the thumb test. And secondly, e-tax residence for bloggers, Instagram travelers makes no sense in the current frame of tax residence, and in the current frame of Russian international taxation. We have to renegotiate our double tax treaties to cover special tax regimes by these treaties. Concerning e-residents in Russia following the Estonian experience, so based on migration law, I don't think that there is some sense to introduce such a regime, because Estonia is the first country. So this country has already collected foreigners, and we will be the second, and Ukraine will be the third, and so on. So as such, this is my considerations concerning e-tax residence and e-residency in Estonia. Thank you for your attention. I'm ready for your questions.
Thank you very much, Elena. And I would ask the panel if there are any comments or questions regarding Estonian developments. So
actually, I do have question.
Yeah, please.
So my question to you, so first, thank you for your presentation. It's really very interesting. And my question to you, you said that individual entrepreneur status, well, if somebody choose the individual entrepreneur status, there will be no social tax from employer. Do you know how that might affect the future, like, for example, pension stuff, etc.? Like, for example, if you like, based on the US experience, if you are not like paying social taxes, so then when you will be like, you know, on the pension like age or something like that, you will be not eligible for get some benefit from that. Do you have like any ideas how that might affect the future? Like, you know?
Thank you, Valeria. I understand your question. Thank you. So concerning the future pensions for such a category of taxpayers, if a natural person is an individual entrepreneur, this person can choose the simplified special regime or professional income tax. And in the first situation, he will pay social taxes, and in the second situation, he won't pay social taxes. Concerning pensions will be for these persons because this tax 4 or 5% of his income will be distributed between federal, between regional budgets and the budget of the pension, our Russian pension fund. So pensions will be concerning medical support. Medical support will be, and medical support is public goods for all our citizens. But concerning social insurance in the situation of temporary inability to work, it won't be, and maternity, it won't be as well. So pensions will be, medical, free medical support will be, and this is convenient regime for the self-employed.
Got it. Thank you.
Thank you.
All right. I suggest that actually it's a very interesting topic, and the more of such developments will follow, and I just would like to notice that Estonia is not the only small country in Europe competing for these international labor force, like IT guys, like these digital nomads, or people like this. Also Serbia is coming into this tax competition. Greece is coming. All the countries which suffered from pandemic because of decline in tourism are introducing different tax incentives to attract this global workforce, and such developments lead to very I would call them methodologically unclear discussions about how all these social security and tax systems could work when people are migrating and they are not anchored in one country. And as we see that our tax treaties and article related to taxing the personal income is very outdated and actually do not address all these concerns. And I don't know, maybe in several years we will see the second, or not the second, but the third wave of BEPS for individuals or something like this. I think this is all very long story and with large consequences. Thank you, Elena. And actually, we are going further. We have another three speakers, and I suggest to go first to transfer pricing, because we have two speakers who are focusing on this, and also we have one speaker focusing on digital economy, which will logically be the continuation. So maybe Valeria could share with us her story, her case about Coca-Cola case, and a little bit refresh our discussion with this transfer pricing development. Valeria, you are welcome.
Okay, so yeah, I got it. So I feel like I'm talking, but nobody hear me. So, okay, so hi everyone. First, I want to say thank you for invitation. I think the discussion of this session is really essential, and I'm glad that I was able to make it today. So today I'm going to talk about the Coca-Cola case, which is the most recent case in the transfer pricing in the United States. So let's get started. So in the end of the year 2020, the IRS, the tax court served up a major victory to the IRS when it upheld the agency nearly $10 billion transfer pricing adjustment against to the Coca-Cola company. So this decision is worth about $2.5 billion in additional tax from the company. So it's a really very big win for IRS. It's really unusual for the several reasons. So let's go and see the background. Just to talk a little bit about background. So this is I provided you like simple. This is the simple version of their what happened. I'm not gonna go through like details and deep because there are so much nuances, details, so it will take much more time for doing that. So basically what we have here, we have Coca-Cola company, which is US Corp, and holds the rights to intangible property, including trademarks, brand names, secret formula, and etc. And then we have supply points. So basically, Coca-Cola was licensed to foreign subs, and these foreign subs located in different jurisdictions, including Brazil, Chile, Mexico, Costa Rica, Egypt, Ireland, and Switzerland. So the supply points using the license could make and sell the drink concentrate to the independent third-party bottlers. And then this third-party bottlers will produce the final products and then distribute to their retailers and the rest of the world. So it's like in Africa, Asia, Europe, and Latin America. The important key facts that I want to mention that supply points compensate Coca-Cola by using the closing agreement with IRS dated in 1996. And this particular agreement was for the period from 1987 till 1995. So the company reason why they use this particular agreement, it's kind of nobody knows exactly, but the logic was that the company think that in this particular agreement there is a roll forward, like, idea of this agreement. So they use it, and also they use it like a 10-50-50 method. So 10-50-50 method determines that the 10% of gross sales of profit will stay in the supply points, and 90% will split equally between Coca-Cola Corp and supply points. Also, like Coca-Cola Corp held that, like, said that supply points held the valuable intangibles. And by saying valuable intangibles, they meant that it's kind of marketing intangibles. So this is the kind of brief background. Let's talk about the main issues. Of course, there were a lot of issues in this case, but the main dispute was about, could Coca-Cola rely on the terms of 1996 closing agreement with IRS? And if so, if not, what transfer pricing method Coca-Cola had to use? So how the tax court come down on these issues? So basically, tax court firstly said that Coca-Cola was not able to use and rely on agreement dating 1996 because this agreement had expired, and there is no evidence and no proofs that in this agreement there were roll forward, like, ideas, or roll forward, like, kind of paragraph or something saying that this agreement has roll forward a potential. Nothing. So therefore, court denied the taxpayer ideas. Second one, I'm sorry.
Valeria, sorry. Yeah.
Sorry. I switched to the next slide. So the second one, second point that court ruled is that court ruled that supply points actually do not have valuable intangibles or marketing intangibles. Why? Because court went through their contracts with Coca-Cola and supply points, and there were no evidence and there were nothing that's saying that the supply points will have these intangible marketing intangibles. And therefore, court decided, and after like many discussions and like providing any proofs, court agreed with IRS approach in order to determine transfer pricing method. So basically, IRS said that based on the facts, IRS said that it should be used, the company should use comparable profits method in order to, and by using this particular method, so the profit should go to their U.S. corp and in form of royalties. So and also court reject all like transfer processing methods that were proposed by Coca-Cola company. There were many of them, but the court says no, it's not eligible. We're using the method that the IRS provided to us. So why, you may ask me, why this particular court decision is important? Well, I'm going to say that this court decision is important to us because it definitely affects the future litigation of transfer pricing here in the United States in the different ways. First, I'm going to say that the IRS success in that type of case with the well-known company, Coca-Cola company, is a very big deal, because we know there were three like also well-known cases like Amazon, Altera, and Medtronic, where the court ruled against the IRS, and this is kind of the first court decision when where IRS win. So we think that, and we kind of looking at this particular case, and we're thinking that it may kind of create opportunity for IRS to be more comfortable and to feel more comfortable in transfer pricing litigation for the future. The second thing that may affect future transfer pricing here in the United States is that during this particular case, the court decision was quite different from a lot of previous cases in terms of determination transfer pricing method. So kind of this is kind of new, and we see like when we're analyzing this case, we're trying to see if that will be kind of next, if it's going to be the short term like perspective, or it's going to be the long term perspective. I mean, when the tax court use the different transfer pricing method in particular cases. So it's really kind of interesting to us. It's really very unusual, and it's really like, kind of important to understand as well. So my presentation is that's kind of it for today. So it's really kind of short, but I'm glad to answer for any questions that you might have.
Thank you, Valeria. So, are there any comments or questions from the panel? So, as far as we don't have them yet, I have my own actually.
Okay.
Maybe it's some kind of simplification of the corporate structure which you presented. However, I didn't notice any law tax environment, any law tax jurisdiction. Was there any, or I don't know, some kind of subsidiary or in the corporate structure, because usually in transfer pricing cases there is there is such a entity in the corporate group. So or this case is more about profit reallocation between rather high tax jurisdictions.
Okay, thank you for your question. So I would say that yes, this is case more about profit allocation. It's not about like it's not about like structuring question with low tax jurisdiction. It's more about like well-known company, but why they use this agreement and why they use particular this method based on this agreement. There were a lot of questions, and therefore it's kind of very unusual. Really, it's it's not about like structuring, but it's more about kind of different story about like profit and like how they allocate the profit and what method they used and like what agreement they used. It's more about like in that particular area kind of case. Therefore it's really very unusual, I would say that.
Okay, thank you for clearing this, because actually for me it looks like I'm don't familiar with the technical details of this case. However, from your presentation, I have a impression that it's quite the opposite idea from the one which we today could observe in OECD Pillar 1 discussion. Because actually all this discussion about relocating more profits to market jurisdictions based on the idea, actually one of the ideas discussed by the OECD was marketing intangible. And here you present that we see quite the opposite, that the profits was allocated back to parent company jurisdiction, and the idea of marketing intangible was actually denied by tax authorities, that you don't have intangible, you don't contribute. We at the parent jurisdictions have economically created it, and so.
Correct. I mean, yeah, you're absolutely right. And if you want, I'm gonna like, can share the link to this particular court, but I'm gonna say that it's gonna be like 95 pages of these court decisions. It's not just like simple decisions, but I didn't want to put everything and like, because it's really very heavy. But the idea was that you're absolutely right. It's more about like bringing back all profit to the to the parent company. So therefore I decided to present it. So I think it's going to be interesting to see the different type of cases.
Taking into account the tax policy position of US in Pillar 1 discussion, maybe it all fits in, because actually their position in digital discussion also is about relocating more to the parent company. So thank you for this, Valeria, and I think we will proceed, and we have Martin from Switzerland, and I suggest Martin could share with us his reflections about the arm's length transfer pricing and related points. Martin, the floor is yours.
Many thanks, and also many thanks for letting me participate in this panel. Maybe it's less a presentation than more a discussion I would like to have. And we have over the last years, we had several mutual agreement procedures, and some of them were connected to transfer pricing, some were beneficial ownership cases, whatever. And the more we looked into the matters, the more we saw that maybe one of the issues is that the unity of the legal system, there is a hiccup in the unity of the legal system, in the sense that you have the double taxation agreements and the measures to resolve double taxation cases on the one hand, And on the other hand, you have the domestic legal system with all the legal remedies to appeal through the court to the Federal Supreme Court. And if you look at these situations, it's not a perfect fit between the remedies that you have under the treaties, which is the map, be it now in the sense of an APA, of an advanced pricing agreement, or be it a map that you initiate when you already have a conflict with the tax administration. And then, of course, you have also within that second route, you also have the distinction whether you have an arbitration clause or not. So, starting with the domestic tax system, I mean, you have the possibility of tax rulings in Switzerland, which is not a legal contract. That's most often misunderstood. It's just, in a way, it's asking a written question to the tax administration, and the tax administration answers that, whether they agree with your interpretation or not. That is commonly used. So that is in an early stage, and in a way you can compare it to an APA. The tax ruling is not in a conflict situation, but you started before, and most often you started before the legal situation has materialized, which most often is a requirement to start a ruling process. And then you have the situation where you get an assessment, you get a tax bill, and you appeal against it through the domestic appeal through various court instances. So that's the domestic part, and then you have the treaty part, where you can either go through an APA, and I think it's, at least in Switzerland, it's still the predominant interpretation that also in APA, the taxpayer is not a party to the APA, but the APA is really an agreement between the two countries, if it's a bilateral or a multilateral agreement. If it's a unilateral, then what normally happens that the Secretariat for International Fiscal Affairs of the Swiss Federation, they hand it back to the cantonal tax administration, and then it becomes a simple ruling. But if it's a bilateral or a multilateral APA, then it's always seen as an agreement between the countries. And the same is true for a map where you already have a negative decision of a tax administration. There it's also clear that the taxpayer is not a party to that agreement. And it's also clear that the classical map, you don't have a right for a decision. The two countries can agree to disagree, and that's the end of the story. And that's why when I started my career decades ago, when you heard the term map, it was already really, you were alarmed, because you had it was a never-ending story, and the worst, you had no right for a decision. And I'm aware that Russia may not have many treaties that already have arbitration clauses in it. Is that is correct, right?
I think so.
We have treaties with MAP. However, we don't have binding arbitration. It's a principal position of Russian, not only Ministry of Finance, but rather the Ministry of Foreign Affairs, because Russia is very like country who cares a lot about its sovereignty, and so the very idea that any other country would decide the question about the allocation of fiscal revenues to Russian budget, or absence of such allocation could not be accepted. It's like Russian territory, like something like this from the Ministry of Foreign Affairs point of view. I suggest.
Yeah. Well, Switzerland in a way has a similar approach. That's why we are not part of the European Union, but still we have treaties with arbitration clauses, and there obviously you have a right for a decision, so what is interesting is that if you go for a classical map, and you have an arbitration clause, you have to be very careful, because you lose, that's the Swiss interpretation, that you lose the right for an arbitration as soon as you have the first court decision. So you can only go through a map ending with an arbitration if you don't have a court decision. So that means the timing is key here, that you have to be careful when you negotiate with the tax administration. And in most cases in Switzerland, you have the reconsideration by the tax administration deciding the case. So you can circle back. So before it goes to the court, you have a second bite to the cherry, so to speak, to the same tax administration. And then, of course, you have to carefully consider what you do, whether and it's the tricky thing is, of course, you can apply for a standstill in a court procedure, but it's very unclear whether you have a right for that standstill. So that means once the tax administration has taken a decision, typically you have a 30-day deadline to appeal to the court. And then once it's with the court, you have to apply to the court for a standstill when you start the MAP procedure, because the MAP procedure takes forever. And typically the court will decide faster than the decision in the MAP procedure. That's why you have to be very careful, and I would be interested how that works in other countries, that you really don't miss out on the arbitration opportunity because a court decision has been taken in the meantime. On the other hand, you don't want to lose out on the 30-day deadline for the appeal, right? So it's really a tactical exercise how to balance out these two ways. And I mentioned the lack of the unity of the legal system, which I think comes here into play. And I would be interested, maybe from Frigo or whoever has seen these cases, how that is dealt with in other countries.
Oh, sorry.
Frigo, could you share how does this work?
I'm back.
In the
Yeah.
Netherlands?
Sorry, sorry, Martin. Could you repeat that question again?
Yeah, we have this in all treaties where we have arbitration clauses. We have the problem that you lose out on this arbitration opportunity once you have the first court decision. So you have to make sure that you stop the domestic legal remedy to go through the MAP procedure, because if you, during the MAP procedure, the first court decision is issued, you lose out on the arbitration opportunity.
Interesting.
That's the one thing. And the other thing, of course, you don't want to lose out on the legal remedy. So if you get a decision by the tax administration, you have to take the opportunity to appeal. Otherwise, you run out of the 30-day deadline, and then you can no longer go to the court procedures, right?
Yeah. Yeah, interesting. I haven't seen that there. I think we don't have such a limitation in the Dutch law. I think that what I've seen so far is that if there's a conflict on interpretation of the treaty, that that we stall the discussions with the tax authorities. So let's okay, Ministry of Finance or tax authorities, approach the other treaty state and see whether you can resolve that. But you don't lose. I think you don't lose your appeal right. It's just paused for that moment. At least this is how I've done it so far.
No,
So
I think you don't lose. It's the other way around. If you don't lose the appeal right, but if the court decision is taken in the appeal, then you lose out on the arbitration opportunity. You still have the MAP procedure.
Yeah.
But you no longer have, if the countries do not agree.
Yeah.
Then you have no longer the opportunity to bring it to the next level, to the arbitration.
Yeah, maybe I don't know. I haven't checked that yet. Sorry, but I will check.
Sure, no problem.
All right.
And of course, that what does that mean actually? I mean, it means that APAs, be it now bilateral, unilateral, or multilateral.
Yeah.
Sorry.
I think it's just a random technical.
Ah, okay. So that means multilateral, bilateral, or even unilateral APAs are really advisable in all cases where you have a case to make, because this conflict resolving route with these two ways, the domestic remedies and the treaty, the MAP, is a very tricky way to go. There are a lot of pitfalls in this way. It takes forever. So I think, and I'm not sure what the Russian approach to APAs is, but we more and more advise, especially now as all the countries need money and the transfer pricing approach has become, I think in most countries, a little bit more aggressive, to say the least. I think APAs are really advisable. I'm not sure what the Russian approach to that is.
Yeah, actually, I could comment regarding the problem you mentioned regarding the tactical decision either to go to court or to apply for MAP in Russia. Actually, MAP until very recent times was a very rare instrument in Russia. Legally, the rules they presented in tax treaties such opportunity, and there probably were some MAP. However, there was no publicly available statistics. And from Russian IFA branch discussions, also it followed that very low share of experts actually were involved in such processes. However, there were some, but very rare. The situation probably changed after BEPS Action 14 recommendations, because Russia's IF member tried to a little bit update both its legislation and what is even more important, regulation, which is like a secondary legislation with details actually what to do, how to apply to for MAP. And now we have rather detailed regulations. So going to your to the mentioned point about either you have an opportunity to apply for MAP and to go to court. Actually, you can. If you read Russian law, you can. However, if there is already, you can apply for MAP actually during 3 years after the decision of tax authorities. 3 years.
That's typical, yeah.
Yeah, and this is what OECD also recommends in BEPS Action 14. So it's like a best practice, something like this. So
Right.
actually it looks like okay, but you in Russia, you as far as I know, you can be involved even simultaneously, both in court dispute and in MAP. However, you shall disclose all these in the package when you provide the package of documents to the Ministry of Finance. And actually, Ministry of Finance have 90 days to decide either will they proceed with your case. They can they have the right to reject on different bases. It's all written. However, it is explicitly mentioned that you shall provide information either there is any proceedings in court currently, and if there is, only if the decision by the Russian court already have been made. Only in this case, your chances for MAP are almost zero. However, if the final decision by the final instance is not made, so you can still apply it. So there are no restrictions. However, from purely practical point of view, maybe situation is changing today, because now we have these regulations, and actually the instrument is more popular now. However, it is not like automatical, and only the largest taxpayers who are very sure with their positions and who have a very large sums of taxes at stake and very good tax advisors, they actually go into this because it's like it's not a common instrument, and it's very uncertain. Going to court is in Russia is more like a certain provision, because we have especially if we compare this with the speed of court proceedings in some jurisdictions. In Russian courts may be called high speed courts, like high speed rail, because they are working rather fast. Actually, I suggest that 3 years, maybe during two to 3 years, all the instances of the courts from the lowest one to the highest can make their decisions. And the decision of the first court maybe I cannot say for certain, but it can take up to, I don't know, five months maybe. And if taxpayer is very sure in his position, probably from the purely practical point of view, the best way is to go to court. However, even before going to court, there is a special procedure when you go to tax authorities, and you can discuss your issue, and it's also this procedure is specially regulated. As for the second part of your question, APA, actually Russia rather also recently introduced the possibilities of negotiating multilateral APAs, which means APAs between Russian taxpayer and the Russian tax authorities, and tax authorities also of another country, and even several countries could participate in this. And however, there is currently no public information about how much APAs were negotiated. The possibility appeared rather recently. I'm not sure, either in 2018 or 2019, something like this. So only 1-2 years ago, and it was only recently updated, and the update was rather profound. And one of the key position was that, which is, I think, fundamental for APAs. Key update was that when engaging into APAs, Russian tax authorities also can probably agree for the application of transfer pricing methods which are not prescribed in Russian domestic transfer pricing legislation. So Russian tax authorities can go on with this if APA is negotiated. So they're probably more flexible when APA is negotiated, and I think it's the very nature of APA to be a little bit more flexible than under domestic legislation. So some thoughts. I don't know. Maybe Valeria also could comment about this issue from US perspective. I don't know. Okay, so
maybe one other point, or maybe my last point, depending on the timing, is I was talking about pitfalls, you know, and I think another pitfall, and that was came as a surprise to us. It was unfortunately it was not relevant in one of our cases, but there were some representatives of the Swiss Federal Supreme Court, and they took the view, at least that's how I understand the statement in the discussion, that once you have a final decision by the Federal Supreme Court of Switzerland on a case, you can no longer start the MAP procedure. And I'm not talking about that you run out of the 3 years. I mean, in most cases that may be the case, because Swiss courts are not super speedy as it seems in Russia. But even if you had a situation where you have all the other conditions met to start a MAP procedure, and I'm not talking obviously about an APA, I'm talking about a reactive MAP procedure, that if the Federal Supreme Court has decided, then even the MAP, obviously without an arbitration opportunity, is no longer available. And that, of course, is also something to consider, that if you want to start the domestic legal remedy way, that you have to switch to the MAP before a decision is taken, a final decision is taken. My understanding was always a different one, but I think to be on the safe side, you have to make sure that you don't lose out on the MAP. And then, of course, it's again what I mentioned before, you have a 30-day deadline to appeal. And if you don't want to lose out on on at least the theoretical option of a decision by the Federal Supreme Court, you have to file the appeal. And then at the same time, you have to file a standstill application, because otherwise you lose out on the MAP. So this is also something that, so I think it's and obviously, it is interesting as an advisor to go through these MAP procedures, but in the interest of clients, I think it's really advisable to seriously consider APA applications. It's a much easier and a much safer way to resolve potential transfer pricing issues.
I could only agree with all your reflections from practical side, but however, I don't see the breach in legislative logic which is we have discussed it both in Russia and in Switzerland. Actually, the same thing, that if there is a final decision of the court, MAP is not available, and I think it's logical from the legal perspective, because country sees some flexibility and some opportunity of MAP, because country considers that the case is not totally clear, and when court have analyzed all the details on the facts and circumstances and put the institutional efforts into this analysis, I think that the court kind of achieved a total clarity, after which country don't see any like opportunity for further negotiations, because clarity already have achieved. And so we are not discussing it. I see this from this perspective, and I think that it is logical. But from the practical perspective, I think that all this MAP is a beautiful and nice article of the treaties, as OECD invented them, but as OECD also suggests, it's in its report, it's not very practical, and we have some countries with a load of MAP cases which are not resolved in a timely manner, and that is why OECD is working on these early certainty projects, all these ICAP programs and things like this, because MAP actually are not very practical. So I think like this.
I tend to agree, especially if you don't have arbitration clauses. I think the arbitration clauses obviously put pressure on the countries to agree, because at least then it's between them. If they don't agree, they lose control, because then it's with the arbitrators. So I think the psychologically, the arbitration clause is an important aspect that, and I'm sure, obviously I don't have the statistics, but I'm sure that in all situations where you have arbitration clauses, that a lot more cases are solved between the countries, just for the mere fact that they don't want to give it out of their hands and leave it to the arbitrators to decide.
Yeah, I quite agree, and I think that is why OECD is putting efforts into making binding arbitration as a new standard. So I think we shall proceed, because we are expiring our time, and we have one more case to discuss, and I would like to ask Ekaterina to share with us her insights about taxation in digital economy.
Well, yes, I shall be short, as I'm the last speaker, and just draw attention to the issues which are falling outside the double taxation agreements, speaking about the indirect taxes. Well, first of all, I shall make a point on the academic side. We, with the colleagues from the Moscow Institute of International Relations, we made a research, and presented an article to the journal International Trends, and we argue that there is a general change of the trend in terms of taxation of digital economy. If we open the documents in 1998, we can find a very optimistic assertions that the tax system is going to cope, no new taxes needed, and that digital economy, and in those terms it was e-commerce, electronic commerce should not be impaired by new taxes and tax systems. And what we see that maybe since 2013, the trend is turning dramatically. And there are hearings in the US, there are hearings in the UK about claiming fair part of the taxes. And basically, it's somewhat continuing the idea and the case which Valeria presented. Then you don't have really the low tax jurisdiction, and the steps taken by the company are in generally legal. However, the technological center like US saying that they don't have fair parts of the tax base and fair parts of taxes. And the symbolic case is the case related to Ireland. This is the European case. Then the Apple used Ireland for for paying less taxes, and again, European Commission looks for different bases. It's not in general tax case. It's a case about unfair state aid to the company. So the tax laws are somewhat not coping with the situation. And what we have in by the end of 20s, we have new taxes. And these new taxes, they are called digital services taxes, and in general, they look like another direct taxes because it's for the tax on the income received from certain services. However, once you have a kind of ring-fenced or separated service and impose a specific tax, it's very likely that we are dealing with some kind of excise duty like it was before. And it's not only my finding. You can have a look at at an article in Intertax 2020 last year. It's called digital consumption tax. So in general, seems like the history of taxation made a spin, and in the digital economy, we have a situation then the states are trying to introduce specific taxes on specific services, which is looking like excise duties long ago. So the history made a spin, and we are somewhere at the beginning, at the initial point. What is the main problem with the indirect taxation? The main conceptual problem is that remuneration goes apart from the service itself. For VAT purposes, there are European cases saying that we have a taxable supply. Only in those cases, then the remuneration is correlating with the service itself. Now we are nearly losing this link between remuneration and the services. And just not to make practitioners to get bored, I would like to draw attention to recent cases in the UK about Uber. So what was found by the UK court. The UK court found that the drivers which are having relations with Uber, they are workers of Uber. And the service of Uber is all basically all the services of taxi drivers. It's very funny that the drivers are not found to be employees, and UK refused to make the social guarantees available for those drivers. So they are not employees, but they're workers. And once they're workers, their remuneration, all the amount, falls within the taxable base for VAT, because then the services of Uber and the remuneration is the whole sum, which is the passenger pays. So that's not, the platform is treated like the provider of the whole services. And I suppose that not only the VAT consequences, I think that it's a very important finding, and we are likely to get to really great mismatch of treating the services of the platform in the nearest future. Then all the VAT mechanism for the double taxation alleviation, which are inbuilt in VAT, they shall not work, because in different countries the services shall be understood differently, totally differently. And I suppose that this finding affecting as well the direct taxes, I shall not stop on this now because, well, my topic indirect taxation, but the notion of service and the notion of remuneration are facing this this change and vague understanding in different jurisdictions. So basically that's what I wanted to say, and I'm ready to answer the questions if any. Thank you.
Thank you very much, Ekaterina, for your very, I could say, broad and academic analysis, but I suggest it illustrates a lot all these digital discussion. Does anybody has some reactions? I think we are almost approaching the deadline, and we are almost on time, and I would like just to very briefly comment about digitalization, my honest opinion, which I think is quite in line with what Ekaterina mentioned. Actually, excises, Ekaterina actually compared all these DSTs with excises, and I think yes, it's like excises, and it's very interesting to understand what's from the economic point of view, what all this is aimed at. Actually, I believe that all these is aimed at like super profits or something like this. And actually, if we dive into the history, excises are also aimed at extracting the same, because excises were levied on what? On salt in different times, on tobacco, on alcohol, yes, on vodka in Russia. Why? Because actually it was a super profits, it was a monopoly. And we have all these digital companies, we have different instruments. Pillar 1 and DST conceptually are very different, but economically they are all targeted the same thing. This like a super margins, but with DST you like have a very primitive and simple armor to touch this, and with Pillar 1 this margin is like relocated with very complicated multilateral system, which is probably more preferable. So thank you all very much for participating in our discussion. I would like to hope that we will meet one time in Moscow physically, but not virtually, because we have this week in spring in Moscow every year, and you all are welcome. So maybe we will end up with this. So thank you for participating today, and
Yeah, thank you very much.
Thank you so much.
Thank you.
Thanks for organizing.
Take care.
Thanks.
Have a good one. Bye-bye.
All right.
Bye.
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 Bye.